Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to tackle a question that a lot of people have asked me, which is about brass knuckles. But not really brass knuckles. What they've been asking is about acrylic knuckles or polycarbonate knuckles or carbon fiber knuckles or all of these different products that are on the market which say these are like brass knuckles except they're not made of metal and so they're legal in Canada. And people say, wait a minute, is that the case? People have asked me, am I going to go to jail if I order one of these? So let's have a look at this. And if you've watched the show, you know that the starting place is often the legislation. So let's have a look at the legislation itself. So here we have the former prohibited weapons order number 8, which notes the device known as brass knuckles and any similar device consisting of a band of metal with one or more finger holes designed to fit over the fingers of the hand. This is very interesting language in terms of how this sentence is constructed, because we see the device known as brass knuckles and any similar device consisting of a band of metal. So that actually narrows the any similar device, because if they just said the device known as brass knuckles and any similar device and stopped the sentence, that almost certainly would have included the plastic, polycarbonate, etc. knuckles. Or if they'd said the device known as brass knuckles consisting of a band of metal with one or more finger holes designed to fit over the fingers of the hand and any similar device, again, that would probably include, plastic knuckles and so forth. However, here they go in a different direction. They say brass knuckles and any similar device. That similar device has to consist of a band of metal, specifically metal. But we can't just stop with the legislation, because sometimes the courts interpret the legislation in ways that can be sort of a substantial shift. The courts may have a very different opinion on what these words mean than you or I. So let's have a look here as to what they're actually saying, because that's always where you have to go, is you have to look for case law. And when we're looking for case law, we of course want the highest authority, the highest level of court that we can. So let's look to the Supreme Court of Canada on this one. This is the case of the Queen and Deschamplain. Now, this is not actually a case about brass knuckles. This is a case about appellate review. However, because it involves brass knuckles, the Supreme Court sort of takes certain things as a given. And when you have the Supreme Court taking certain things as a given, that tells you that that's pretty much what the law is. It's a very strong argument to be making if you're trying to establish here is what the law says. So the facts of this case, as found by the lower court, on May 24th, 2000, the respondent, a member of the Ontario Provincial Police, attended an elementary school with another police officer, Constable Renaud. Both officers were in uniform and on duty. So note, the accused in this, the person who was charged, is a member of the police. The respondent's wife had arrived earlier to search for a knife that she believed was in their son's possession. Her actions were prompted by the alarming notes she found at home written by him. They don't detail what these notes are in the Supreme Court decision, but I'm guessing they were pretty threatening given the context. She called the respondent from the school. So she's the one who calls the accused, and he arrives apparently with his partner. There were allegations that their son had shown a knife to other students and made threats. The knife was found in a box in another student's desk and given to Guy Campeau, a teacher who decided that the police should be contacted. The respondent met with his wife, their son, and Mr. Campeau in the principal's office. Constable Renaud remained in the outer office with the secretary. Starting to see some problems here in terms of how this is being handled? Oh, it gets worse. The respondent told Mr. Campeau that the knife had been recently bought at a flea market for whittling wood, and that he had warned his son not to take it to school. Mr. Campeau suggested that the respondent's son be sent home, and that the principal, David Parks, who was away that day, would decide the length of the suspension. Given the seriousness of the situation, Mr. Campeau asked the respondent about the procedure for laying criminal charges. The respondent told him that it was the responsibility of the police. He also asked the respondent whether he was there as a father or police officer, and the respondent replied that he was there as a concerned father and as a police officer. And you can see here, those two things are kind of in a conflict of interest, right? But Mr. Campeau decided that as a police officer, the respondent should have the knife in order to conduct the investigation and gave it to him. The respondent, accompanied by Constable Renault, then drove his wife and son home. So things get worse. We'll just go with that. On May 25th, 2000, Mr. Parks, the principal, dissatisfied with how the matter had been handled the previous day, contacted the police and requested that another officer investigate the incident. Say, maybe one whose kid isn't involved here and who might not have some incentives to maybe do some things wrong. Detective Sergeant Lalonde was assigned to the case, and when he spoke to the respondent that night, he asked him what sort of knife was involved. The respondent replied that it was a small jackknife. That doesn't appear to actually be consistent with the evidence of Mr. Campeau. Mr. Campeau had looked at the knife in the box after removing the lid, but never touched it. He testified that at the preliminary inquiry that the handle and the grip area of the knife were silver in color with brass knuckle type 4 rings that you would put your fingers through to hold onto the handle. Mr. Campeau did not say in direct examination that the handle was made of metal, and in cross-examination clarified that by using the descriptor brass knuckle type, he was not suggesting that the handle was made of brass. So just to stop here for a second, we may be talking about something along the lines of this. A trench knife, where you can see sort of the brass knuckle style grip, and the courts have held that this is a prohibited weapon because of the sort of brass knuckle elements there to it. I don't know if this is the exact design or what the design was like, but this does not seem to be consistent with a small jackknife. So, Detective Sergeant Lalonde discovered that the respondent had not made any notes in his police notebook, and I'll just stop here to note that police, they take notes all the time. It is perhaps the most used piece of police equipment is the notebook. If you're ever stopped by the police, they'll be there with their notebook. Pretty much any time when they're not needing to use both hands for something else, like if they're involved in, actually subduing a suspect in, combat or the like, pretty much at any time when they're not doing those things, they're writing stuff down in their notebook. And as soon as they're done doing those things, they write things down in their notebook. Because at an eventual trial, your notebook is what saves you. Because when some clever defense lawyer is asking, so did this happen first or did the other thing happen first? The officer is going to say, well, I've got to check my notes. And they're going to check their notes, and hopefully they've kept enough detail that they can present a coherent account of what happened to the court. So not taking notes when they're saying that he's there as a police officer is a major party foul. So he also hadn't completed a police report about the incident or secured the knife as an exhibit. The respondent never complied with a subsequent request to turn the knife over to the police. So knife is gone because they handed it to the kid's dad. Yeah. So as a result, they're coming after the officer for 2 counts. The first is possession of a prohibited weapon, contrary to Section 91 sub 2, and obstruction of justice, contrary to Section 139 sub 2, because they're saying the allegation here is that he made evidence disappear. So that's why he's charged with that. Now, this is an appellate decision, so we get to look at what happened at the lower court. That's the starting point here. So they note a preliminary inquiry was commenced before Judge Surrey of the Ontario Court of Justice. 3 witnesses testified for the Crown: Guy Campeau, Detective Sergeant Lalonde, and Constable Renault. The matter was adjourned to May 30th, 2001, when counsel made their submissions on committal. The judge rendered her decision the following day and discharged the respondent on both counts. As a prohibited weapon, brass knuckles are described in the regulations prescribing certain firearms and other weapons, components, and parts of weapons, etc., as consisting of a band of metal with 1 or more finger holes designed to fit over the fingers of the hand. In the view of the judge, on the strength of Mr. Campeau's testimony alone, the Crown had failed to adduce any evidence that the handle of the knife was made of metal, and therefore an essential element of the prohibited weapon charge was not met. She concluded that a discharge under the second count, obstruction of justice, resulted as a matter of course. The judge made no reference to the circumstantial evidence, including the evidence presented by the other witnesses. Now, I'm not going to go through all of this because most of this case is really about when the courts can step in to correct a judge's error at a prelim. But I will note that they do send this matter back for another trial, and they do so on basically 2 reasons. The first is that when she says that, and she here being the judge, that a discharge under the second count of obstruction of justice results as a matter of course, this is because she had decided that there's no evidence that this knife was a prohibited weapon, and so therefore he can't be obstructing justice if he's not presenting a prohibited weapon to the police. And frankly, that argument just doesn't make a whole lot of sense, because even if the evidence is evidence that acquits somebody, the officer is required to secure that properly and to make sure it gets into the evidence locker. You know, he can't be like, well, this evidence isn't, this isn't evidence that specifically convicts anybody, so therefore it can just disappear. We've got to have all the evidence, especially sometimes evidence that acquits somebody. Because let's say that he's right. Let's say that this was actually a small jackknife, and that this, this teacher, Guy Campeau, is just making stuff up. He's saying that it's this, trench knife, and it's all these super dangerous things and so forth. Maybe it's just a tiny little folding knife, in which case, if the kid is charged, the son, he'd certainly want that knife to be available to evidence so he could say, no, it's a small jackknife, right? Or if it is the prohibited weapon knife, that's again important. And similarly, the officer has a duty to take notes. And the Supreme Court sort of said all of the above. They basically said on that count, it has to go back because the trial judge just failed to consider any of that. Now, with respect to the brass knuckles aspect, there's two ways they could have gone. If they had not thought that the metal aspect was key, they could have said, well, the learned trial judge had failed to properly consider that non-metal knuckles would have been prohibited, but that's not what they did. The Supreme Court agrees that that's an essential element, but they are concerned because they basically figured that the judge didn't look at circumstantial evidence that might have established that they were metal knuckles. And so that's why they send it back. Kind of my own personal thought is that I kind of suspect that they might have felt a personal inclination to send it back, because this is really a case where the Crown could very well have lost this one for failure to ask one critical question. When you had those, that knife in your hands, what was it made of? Can you describe what the knuckles portion was made of? And he says, oh, metal. Do you know what kind of metal? No, I don't. But it doesn't matter. It could be made of tin. It could be made of steel. It could be made of aluminum. Whatever kind of metal is enough to meet the test there. So what we can see is that there is Supreme Court jurisprudence that says metal is necessary. So when those sites tell you that plastic knuckles are legal in Canada, they're not wrong. However, major caveat on this, because our old friends, possession of weapon for purposes dangerous to the public peace and carrying a concealed weapon will rear their ugly heads if you decide to buy one of these and carry it around for self-defense. Because, as I've said in many videos, the courts take a very dim view of carrying a weapon around for self-defense against sort of ordinary unknown dangers of the universe that we live in. So if you're carrying around a pair of plastic, a set of plastic knuckles because you're worried that you might get attacked by, somebody in general, a mugger or whatever, you're going to have a bad time, especially because you're not very well going to be able to argue that these things aren't weapons, because they're very much obviously purpose designed as weapons. The courts have, in fact, sometimes used brass knuckles as sort of one of the prototypical examples of something that is designed for use as a weapon. And similarly, if you're carrying around a set of plastic knuckles or the like, most people would be tucking that into a pocket, at which point you are in the realm of carrying a concealed weapon and you're facing charges. So these things are perfectly fine to buy and put up on your wall as decoration, but they really shouldn't be leaving your house, or else you're running all sorts of risks in terms of getting charged and potentially going to jail. And if you're a gun owner, expect that if you are charged and convicted with that sort of weapons offense, that you may also face a firearms prohibition, which is a big deal if you're a gun owner, because sometimes that means tens of thousands of dollars worth of stuff lost. So I don't really recommend these. I don't own a set because I don't have a whole lot of use for it. You know, I like my wall art. I don't think a set of plastic knuckles would look terribly spectacular up there. But if that's something you want to buy because you're a collector, that's fine. They're not illegal to simply possess, but don't carry them around. You will get into trouble. You will not like where that goes. At any rate, thank you for watching. I hope this has been educational. I know this is a question that a lot of people have asked me, so hopefully this answers that question. And some of you have indicated that you've been having online arguments about this. So for those of you who have won those online arguments, and for those of you who haven't, sorry, this is just the law. It just is what it is. I want to thank $30 Patreon Steve Browning and $50 patrons George and D. Mo, as well as the $10 patrons who will be immediately following in the crawl below. I'm going to have a link to the case in the description, as well as some credits for that picture I used, and also a link to my Patreon if you want to help contribute. Thank you for watching, and I hope this has armed you with knowledge.